Hey guys, hi everyone, and welcome. I am an apostate. My name is Apostate Alex, and welcome to my channel. For those of you watching here, I'm joined by the lovely Zac Morgan, your lawyer friend. Thank you for joining. Hello and welcome. This is our first live stream together. How's it going, Zac?
It's good. Thanks for having me, Alex. I appreciate you reaching out. And I know sometimes it can be tough to coordinate my workday schedule, which ends at 5 p.m. my time, which is almost middle of the night your time, but not quite. So I appreciate accommodating me. And to Alex audience, for those of you in the UK and around the world, if this is way after your bedtime, I appreciate all of you joining in, tuning in to join us tonight.
No problem. I'm actually going to put your link in here. Follow Zac here. There's a link in the chat to your YouTube channel. If you're not already following Zac, go and click that link, give him a subscribe. And how long have you been on YouTube now? It's quite a new thing for you, right?
Yeah, so I started contributing back with Aaron Smith-Levin, I think back in maybe October, November of 22. But I
Yeah.
started my own YouTube channel at Aaron's urging and many of his subscribers urging back in, I think, May 16th or 17th of this year. So just, less than 90 days ago. And I'm just under 7,000 subscribers. So appreciate all the support from everybody, from Aaron, from you. I see you in my chat all the time, and you always throw up really good, interesting questions that help, I think, help educate the public in a way that the average Joe can understand the complexities of legal process.
Oh yeah, for sure. I love the complexity of it. And it's law for me is so I've always found law really interesting anyway. So when I went to university, I did history as a degree as a first year. And the reason I did that was because I wanted to become a lawyer, right? That's actually where I was at in my headspace before I joined Scientology, because I wanted to go and become specifically a corporate lawyer working with companies and corporate law and commercial law here in the UK. And I had an offer from a law firm that if I did a history degree and then did a 2-year conversion to law, they would pay for the conversion, but they would appreciate that because it gives me a better understanding in a different subject, and they valued that as a company. So I had this massive interest in law, and actually Scientology got me in because they offered me a job in OSA in the legal section working on their lawsuits. They were like, yeah, we've got tons of lawsuits. You can come work with us and get some great legal experience. I was like, okay, great. And then I ended up not doing that, of course, and then ended up changing my degree and doing marketing and something completely different. But I've always had an interest in the legal system and the way it works. And I thought it'd be great to bring you on and fire a load of questions at you with your legal experience. And yeah, thank you for coming along.
Thank you. Well, thanks for having me. And a lot of folks may not understand this, that the entirety of the U.S. legal system is actually based on the English common law, with the exception of state law in Louisiana, which is, of course, French influence. So it's the civil law, or the law written literally in giant books, what we call the code, the Napoleonic Code. So Louisiana state law is based on the Napoleonic Code, but the rest of the United States, including the federal court system, is based on British common law. And occasionally we'll actually come across a U.S. case opinion that cites to the King's Bench or the Queen's Bench, depending on whoever the monarch was at the time of the opinion. And we actually study some British common law cases in law school that lay the foundation for contemporary American common law.
Wow, that's amazing. I think also, as a preface to this conversation, please bear with me because there are some things that are very similar in British and US law, but some things that are vastly different. Like a
Yeah.
prime example is, your whole state system. You have state law, you have federal law. Like we don't have a federal system and we have a local authority government thing, but the law is written and decided by members of parliament, which is in it's a politics thing, and then it applies to the whole of the UK. And there are some small matters that are different in England, Wales, and Scotland, but ultimately the law is the law, and that's kind of it. And so there's some big differences like that. So I may ask you what might sound like really stupid questions, but that's
It's
just
all right. That's part of it. Part of what I try to do is educate people on all aspects of the law. I think understanding different cultural applications of the law helps create better cultural appreciation and understanding across states and nations. And one of my bucket list items, and I don't have the contacts to do it, but I would love to interview the Right Honorable John Bercow, who just, of course, left, I believe, in 2019 or 2020 as one of the longest tenured speakers of the House of Commons. And just watching the way his leadership style evolved through his tenure as the Speaker of the House of Commons. And one of the things that I've studied, that The Speaker of the House of Commons is very different than our political leadership. The Speaker of the House of Representatives is a partisan position that represents the majority party. And in Parliament, both in the House of Lords and in the House of Commons, when you're elected as the Speaker of your respective House, you set aside your partisanship. You step away from your political party, and your job is to shape the debate and allow all sides to be equally represented. So, although I live in a constitutional republic and you live in a constitutional monarchy, while there are some similarities, there are some fairly significant differences, including, there's some shows like Border Security UK where it talks about immigration control in the UK, and you see somebody get arrested, and what the UK authorities read sounds very similar to what we call the Miranda rights, the right to remain silent, the right to an attorney. If you listen to it, it's actually quite different. It sounds similar, but the legal effects of it are very different. Here in the US, for example, I can never be compelled to make any statement or produce any evidence ever, but certainly not if it may tend to incriminate me. The exact opposite is true under UK law, as I understand it. They will tell you you're under arrest at 5:14 p.m. You do not have to make a statement. But if you do not make a statement now, but then later make a statement which you rely upon in your defense, we're going to attack it in court. So it's the exact opposite protection. Yeah, you have the right not to say anything, but you can't not say something now and then raise a defense later. You must tell us now all defenses you intend to raise in disputing the allegations we've made.
There's also some really big things like in the UK, they will never arrest you for doing something. They'll arrest you on suspicion of committing X crime, right?
Yep.
If you are very clearly seen, murdering someone, they will never grab you and arrest you for murder. They'll arrest you on suspicion of murder, because then there's a whole, there's a whole legal thing around that. But yeah, the wording is very important in that, no, you're arrested on suspicion of committing this crime. And then we did the legal work, we did the investigation, and then we decided, no, you did this crime. And then you'll be charged with the crime of murder or whatever. But it's just some key differences like that are interesting. But I don't want to get down too many rabbit holes. We're here to talk about Scientology, right? And do you need to give any disclaimers or brief info about what your credentials are, what you're talking about, what you can and can't say and can and can't do as a legal professional before we jump into this?
Yeah, absolutely. And it's especially considering probably a large part of your audience is British. Some of the folks who are with me on my Friday night hangout now, heard this. Any answer that I give is my opinion. It does not represent the opinion of my employer or of my law firm or of the law in the United States. When I tell you what the law is, I'm giving general examples. As you mentioned earlier, each state is different. The national legal system is even different than that. So I'm giving you the general principles of law, but it could be nuanced. And so people ask all the time in the question, what about X? My advice is always find a licensed attorney in your jurisdiction or your state where you live and get legal advice specific to your law. Secondly, if you wonder, well, is Zac my attorney? If you have not signed a fee agreement and a waiver with me, and you have not paid me any money or put down a representative retainer, I'm not your attorney. So there's a legal contract that establishes the attorney-client privilege. Thirdly, I do not talk about my children, other than people know that I have, a new baby and a toddler, and they know that I'm married. I don't discuss, describe, or otherwise identify my children or my wife. Unless I choose to do so, but that's sort of irrelevant to the conversation. And also I try to base every answer that I give will be based on my experience, my knowledge of what I believe to be true, and as a result, sometimes my answer is going to be I don't know. I feel like it's disrespectful to the audience to give them an answer that I don't reasonably believe to be accurate in some facet. So I'm not afraid to say I don't know, and occasionally I get the question that I don't understand, but for the most part, I try to answer to the best of my ability everything that I'm asked.
I think that's great. And that's why I wanted to bring you on, is I love the videos you've been doing with Aaron, and I really support your channel. And what I wanted to talk about is something that hasn't really been discussed. And I thought it'd be great to get some legal kind of opinion on it, as from your view, understanding the US legal system. And similar to me, I'm not a lawyer and I'm not an expert in the UK law, but I have a fairly good understanding of certain things based on the research that I've done. And I thought it'd be interesting because when we talk about Scientology, they are a multinational organization that have different legal entities in the US, in the UK, in Australia, everywhere else in the world. And I thought it'd be good to get, considering they're tax exempt to the US, and that's very much where all the money is funneled to get your thoughts on what the US kind of law, like legal position would be. So like when we talk about Leah Remini and her harassment case, her case at the moment against the church, she's requested a multitude of things, but one of the things she asks for in her what's the word, the request, I suppose.
Yeah. In her complaint alleging the
Mm,
allegations, she both makes allegations about what she believes has been done to her illegally. You also must make a demand for remedy, whether that's money damages or an injunction or declaratory judgment. I think all of which she's seeking in her case. So
mm.
you both make a claim of what was done against you that was wrong, and then you also seek payment through damages.
Sure. And one of the things that she requests is that not just harassment against her stops, she actually requests that all harassment, fair game, that whole policy Scientology are known for, it ceases, and that's not just to her, that's a global implication of stop applying this policy. I
Sure.
think a first question is, this is a California lawsuit. A, how likely is it that ruling could be made? Like, could a judge decide to make that ruling? Is it possible to say, yes, you as an organization need to stop doing this globally? And secondly, if it was to be made, how does that affect their operations here in the UK or in Australia or whatever? Because they
Sure.
wouldn't have to comply with US law as a UK organization, surely.
Sure. So your question is fairly multifaceted, and I
Mm.
like it. So I'm going to sort of take the legal points of them one at a time. So first, it is absolutely possible. What she's seeking, other than the money damages, is what's called declaratory judgment, where the judge says, as a matter of law, you, the organization, are doing things that are unlawful, and you are hereby commanded and ordered by this court to stop. Um, we saw in the US the very same thing in the 1990s, and I don't follow F1 a lot, but I believe tobacco still is allowed to advertise on F1. I don't know that, but I still think I see some like Marlboro style of tobacco products as sponsors in Formula One racing. And I'm trying to use some European style references for your viewers because they may or
I
may
mean,
not understand
to
NASCAR.
be fair, most of my viewers are American, which is why I do late night streams anyway. But there are a
Okay.
portion that are UK. So,
Okay.
and yeah, but fair
Yeah.
enough. Go for it.
So and there are still, as I understand it, tobacco companies are still allowed to market, advertise, and sponsor
Mhm.
in Europe. And I can't speak specifically for the UK since they left the European Union in a completely different disaster, but through
Don't
Brexit.
get me
But
started.
yeah, exactly. Um, in the United States, tobacco companies cannot advertise. They can't sponsor drivers. They can't run ads on television. Um, Occasionally, you'll see a new product like tobacco-infused vapes hit the market, and then they were quickly banned from advertising. Um, Now they are in a limited capacity. For example, if you go to what we would call a convenience store, a gas station with a store attached, you'll see inside, maybe you're in the parking lot, some banners advertising tobacco products. Generally speaking, tobacco products or tobacco companies are not allowed to advertise.
Mhm.
That was a result of a lawsuit filed in the 1990s that ended up being a national class action, of which Oklahoma was a party and received a settlement from the tobacco companies. But the tobacco companies have a court order that says they're not allowed to advertise in most capacities. In the few capacities in which they are allowed to advertise, it's highly regulated. It's very similar to alcohol. Alcohol in the United States, we can advertise beer. In fact, you watch a football game, American football game on a Sunday, every other commercial is a beer commercial. But what you will never see in a beer or a spirits, high content alcohol commercial, you will never see anybody consuming it. They're holding it, they're pouring it, they're making a drink with it, they're toasting with it, but they never actually consume it. It is unlawful to show someone consuming what appears to be an alcoholic beverage in an advertisement or marketing capacity.
Mhm.
And so there is precedent for this to exist, for the court to say you can no longer do this thing. Is it legal to sell tobacco products? Of course. They have to come with all the dangers that they're unhealthy. Is it legal to sell alcohol? Of course, but there's a warning on the back. Caution, alcohol consumed by pregnant women can harm or kill the fetus, right? There's certain disclaimers. It's absolutely still legal to sell them, but it's highly regulated. And so it is, a court cannot say to any religious organization, you can no longer practice your religion. What they can say is you are no longer allowed to harass, fair game. Um, as you know, the term fair game was abandoned specifically in some literature by L. Ron Hubbard in the 60s. But what it says is the term fair game shouldn't be used. However, all tactics and procedures and whatnot necessary to eliminate the detractors
Hmm.
should be exercised. We just aren't going to call it fair game. You could call it butterflies, but as Shakespeare said, a rose by any other name. Just because you don't call it fair game doesn't make it inherently not fair game. It could absolutely still be the same thing. We just give it a different name. So I think that's the first aspect of it. Yes, it's absolutely possible. Um, I think the next part of it is, let's assume she gets judgment in California state court, and this goes back to what we call the long arm statutes. The United States Constitution. So the way the U.S. is set up, at the very top you have the U.S. Constitution. Underneath it you have federal law. Underneath federal law you have state constitutions and state laws, and then underneath those you have city ordinances. For example, you can't have cattle in town. You can't have cattle ranch in the middle of downtown.
Right.
You have to have your dogs on a leash. You have to cut your grass, and your mailbox can't be so far off the street. Things like that. And so there's sort of these layers to it. Okay, so the supreme law of the land is the Constitution of the United States, and what the Constitution of the United States provides is what's called the Fair Faith and Credit Clause. The Fair Faith and Credit Clause is two-pronged. It says, one, that anything backed by the United States government shall be accepted for full faith and credit. So, for example, bank accounts in the United States, just consumer bank accounts where you put your money in checking or savings account, they are federally insured by the Federal Deposit Insurance Corporation, which is a quasi-governmental agency. Banks pay insurance premiums to them, and if a bank fails, they pay it out. The bank does. Okay, so if, however, all the banks were to fail, and we saw a huge number of bank failures in 2008 during the housing collapse, which ultimately also caused the Bank of Scotland to fail, I believe, and it nearly took out Barclays Bank, right? So certainly the UK and Europe was not immune from that, because these products were being sold as a commodity, but different issue for a different day. And so as when you look at it, the full faith and credit clause says that if a bank fails and the FDIC doesn't have money, they're allowed to borrow from the United States Treasury. Right? That any money guaranteed that's insured, you're never going to lose a nickel of. And since the FDIC was put in place since the Franklin Roosevelt administration, there's never been a nickel of insured dollar lost. It's always been honored. The full faith and credit clause also says that a judgment in one state is recognized by all 50 states, the U.S. territories, and the federal government. So Alex gets divorced in state A, moves to state B, and Alex's ex-wife from state A shows up and says, oh, we're still married. Or more importantly, Alex gets divorced in state A, moves to state B, and says, I was divorced in state A. State B can't force me to pay my child support or my alimony or whatever type of payments I'm due. No,
Right.
if you don't make payments, state B can and will take whatever steps are necessary under that state law to enforce the judgment of state A. So if Leah gets judgment in California, not only is the church not protected in Florida, they're not protected anywhere in the United States. They can't run and hide. Oh, well, we got judgment in California, so we're going to shut down all of our operations in California, move everything to the middle of nowhere, Wyoming. Well, she can still seek their assets and seek recovery of that money in Wyoming. And so when I say the 50 states, I also mean the District of Columbia, Puerto Rico, American Samoa, the American Marianas Islands, and the minor outlying islands, which are U.S. and Guam, which are U.S.
Sure.
territories and protectorates.
So if the judgment was to come through, yes, Scientology needs to stop doing their harassment fair game tactics, and that was the ruling by the California court. Am I correct in thinking all other US states need to therefore enforce that? So if someone 6 months later in, Indiana accuses Scientology of harassing them, they would have to enforce that and say, well, if they were found guilty of harassing another ex-individual in Indiana, they would then get like a harsher sentence in Indiana because they were told not to do it by California 6 months earlier.
So not necessarily, because and this is something I'm going to correct. You're and you're not the only person. This happens all the time. You're collapsing criminal law and civil law.
Oh, okay, right.
Right. So a criminal law, the maximum penalty is prison or the death penalty. Civil law, the worst possible outcome is you have to pay somebody money, or you're prohibited from doing something. Right. It's just it's money. And so if there is a court order that says thou shalt not fair game, by a California court and fair game occurs at the Philadelphia org, that still violates the California court order. And now any victim who is fair gamed after that order can sue for additional damages, but also the organization can also be considered for criminal charges because now they are now violating a judge's order. A judge's order in the
Mm.
United States is law. It doesn't apply to everybody. It only applies to the parties of the case. So we call that the law of the case, but it's law. And if the church is a party to the case, the law applies to them. And not just Celebrity Center LA, not just the LA org, not
Mm.
just the LA Day org, but all parts of the church that are organized in some sort of corporate structure. Um, the Sea Org creates an interesting question because it is not, it doesn't technically exist
No,
legally.
it's not an incorporated. The same
Yeah,
with the IES, the International Association of Scientologists. Technically, doesn't
right.
exist.
But if you look at all of the work that the Sea Org members do,
Mm.
they're doing work for one of the legal entities. They're doing work for RTC, or they're
Yeah.
doing work for whichever division of the organization handles all of the um, the publishing of L. Ron Hubbard material, for example, right? There's money in that, there's value in that. And so Mark Headley, when he was at Gold, his job, if one of his jobs was to make thousands of cassette tapes and VHS tapes and CDs and what have you.
Mm.
Although he was in the Sea Org, he was doing work for a legal organization
He
that
was
markets
employed
and
by them.
retains the intellectual property for these
Sure.
cassette tapes and other media. So even though the Sea Org doesn't exist legally, the work of its members is being
Mm.
conducted for a legal entity. So you're not judgment proof just by virtue of being in the Sea Org.
Does that come into play? So, for example, when I worked in Scientology in London, there was a lot of training that went on at Flag in Florida. And London, the UK orgs operate through an Australian registered charity called the Church of Scientology Religious Education College Incorporated, COSRECI, based in Australia, but operate only in the United Kingdom. It is not, as far as I can tell, owned by Church Scientology International. It's not. I might be wrong, but my research has led me to believe it is a completely separate entity to Church of Scientology International and their US operations. But there were times when people would go to Flag and there would be training to do auditing and so on, and they would come back with files and folders and documents in their hand luggage that we would then keep in London, in whatever storage system. And it was never explained, but it was an OSA thing, and we were kind of told not to ask any questions. But I wonder if, say, for example, there was a lawsuit going on in America where Church of Scientology International were on trial and they were subpoenaed to supply certain information. Church of Scientology International could theoretically say, we don't have that information because actually it's in the custody of COSRECI, which is A, not on trial, B, not associated or owned by, and C, in a completely different country. Does that give them some sort of legal protection? Because they can say, we don't have it. And then it's up to the legal team on the other side to prove that A, you have it, and B, you're hiding it in an international organization. I'm not
So
accusing them of it, but it is a
sure.
question.
So this is where the discovery rules in the United States are super helpful to litigants. Even if we cannot prove a legal connection between the Australian entity, the people who work for the Australian entity in the UK, and Flag or any other US based part of the church. If I ask the church to produce this document, I know they have it, you know they have it, they know they have it. And their answer is, I don't have it. I can also ask, and I will ask as a matter of routine in the written discovery, list every entity, person, thing, green stripe monkey, body Dayton, Zeno himself, list everything or everybody and everybody to your knowledge that has, might have, at any point has, or you reasonably believe to know has
Right.
knowledge of, not even the information, just knowledge of the
Knowledge
existence
of
of
it.
the information. So they say,
Sure.
we don't have it, but they are required to disclose. And here's the thing. If they don't disclose, if they say we don't have it and we don't know of anybody who does, they can find Leah Remini, they can find a former Scientologist who says, I've seen the documents, I've put my hands on the documents, I put them in the filing cabinet. When I saw them, they were in room 6, filing cabinet 13, drawer 2, second divider, third of the way back. I can tell you exactly where it is. Well, now they're going to have to answer for the fact that they submitted not just an incorrect, but when I sign my discovery responses as the attorney, I'm putting my bar license at risk. So that attorney submitted information that they knew reasonably should have known was inaccurate, and that will get an attorney in trouble. And the example of that is, and I'm not talking about the politics of it. If you look at the former president Donald Trump, when he stands at the podium and he yells it was rigged and all this other stuff, right? Even his attorneys will stand at the podium and give a press conference. Not one time. Well, one time, and she got disbarred. Other than that one time, not one time have any of Trump's attorneys stood in front of a judge and argued that it was rigged, that people were manipulating votes. They have no evidence of it. They've done their due diligence and they have no evidence of it. So that's why it's one thing to do it in a press conference or put out a tweet. It's different to say it in front of a judge. The stakes are different.
I understand that. Okay. And then I think I want to move on to, because we've got to kind of wrap this up in 10 or so minutes. So I want to leave time for Q&A and stuff. So I wanted to talk a little bit about finances, right? So
Sure.
I recently launched Scientologybusiness.com, which is a website that kind of talks about the UK legal setup of Scientology and their money operations. And it turns out that Church of Scientology International and Celebrity Center International, Meg, hi, welcome to membership. I don't know if that's your channel or my channel, but thank you. Church of Scientology International, Celebrity Center International, and a couple of other organizations that are based in the States are loaning money to Cosrecki, the UK, Australian-based but UK entity. And their current debt is $100 million, which is 5 times their annual turnover. Right.
Sure.
And every year they are injecting more money into Cosrecki. They are propping it up in the form of loans. And there's a whole discussion to be had about why and the legality of that. But my question is, at what point in US law is an entity or an organization or company considered a financial institution? Because firstly, I imagine it's legal for one corporate entity to loan money to another. But at what point does that become a place where it should be regulated, right? If one company is loaning $300 million a year and actually not making much money on other things, and that's their primary source of income, does
Sure.
that mean they should therefore be considered a bank and regulated and so on? Like, where is that line drawn?
So yeah. So I understand the question. The rub here is that the thing that separates what the church is doing from what a banking or finance institution would be, they're not holding themselves out to the public. Okay. There's a show in the U.S. called Shark Tank. There's a British and Australian version of it. I forget what you guys call it, but it's got the venture capitalist, right?
Dragon's Den.
That's unregulated cash. I just walk in, I pitch a business to a rich guy who says, hey, I want to invest in that. I think it's a successful business idea. I want a royalty, or I want to buy a percentage of the company, or I'm going to give you a loan. It's private money. They can do that all they want to. However, the church is running the risk of getting into what we call fraudulent transfer or fraudulent loan. They're providing loans that they know are not going to be repaid, and they are not going to attempt to secure repayment. So then if judgment is secured by Leah Remini, the church says, oh, we're out of money. We lent it to, this Australian entity that operates in England. The court can require the records of those transactions be produced, including the truth in lending agreements. Under U.S. law, if I loan money, and there are some exceptions to this, but generally speaking, if I loan money, I am required to have it written in a contract. Mm-hmm. It talks about the interest rate, repayments, whether it's a lease or a loan, whatever it is. You have to produce all the documents if requested by the courts. There's a lot of things you have to do. But also, the court can look at that and say, you call this a loan, you call this a finance agreement, this is a shell game, and they can actually claw the money back. Back in 2009, I believe it was, or yeah, 2008, 2009, Bernie Madoff's Ponzi scheme in New York City, but like he turned himself into the FBI because he was out of money. The FBI went back to some of his oldest investors who knew or reasonably should have known it was a fraud. And every time their statement came out, because it was all made up numbers, with their return, they would cash out their return but leave their principal in there. So the only money they risked was their principal. They were cashing out their returns. During the bankruptcy, the court went back to these people and said, pay the money back. You knew or reasonably should have known this was a fraud. You know these are ill-gotten gains, that this is money paid to old investors from new investors, which is a Ponzi scheme, essentially. And they went back and clawed back hundreds of millions of dollars from people who were recovering ill-gotten gains. So there's lots of legal tools that both private individuals and the government, both the state and federal government, have to recoup these funds and it sounds like if in fact it appears that there's some sort of fraudulent transaction going on.
It says in the most recent financial filings of Kosrecki, it's under note 16. I'll put the link in the description, but going concern, it says here, the vast majority of current liabilities are amounts owed to other Scientology organization with whom there has always been a mutual cooperation and who are unlikely to seek repayment to the detriment of other creditors. Church Scientology, Education College Incorporated, maintain healthy balances, blah, blah, blah. But they clearly state in the accounts here that it's unlikely CSI is going to sue Kosrecki for not paying the loans. But the question I have is the fact that they are loaning this money to an overseas entity and they're tax exempt in the US, is that completely legally above board that the church can profit off charging interest on a loan?
Yeah, so generally speaking, there are some exceptions to it, but they probably would get around any challenges to the legality of it, simply because if they say we're only lending the return on where we've invested the donor's money. I put the principal in a savings account and I'm only loaning the interest. If they can show that they're only loaning the interest, but the principal is secure, probably going to be okay.
Can you explain that a little bit more? Sorry, what do you mean? So
Sure.
in this instance, Kosrecki are borrowing money from CSI, CC, and all these other organizations, $100 million totally owned. And then Kosrecki are paying that back plus 5 or whatever % interest. And every year they're paying it back, but the US entities are also then loaning them even more money to prop up because they're not earning enough money in donations to financially support themselves. Sure. So what do you mean in that?
So what I mean is if the US entities, the money that they're loaning, if that money is coming from returns on investments, meaning you as a member donate $100, they take that $100 and they put it in a savings account, and that savings account pays 10% interest, so they get $10 a year on that $100.
And they then use that $10 to loan to Kosrecki.
The principal, the $100, if they can show it's still secure, theoretically they could say, well, we're just investing, we're just loaning the return. That's just the way we're investing the money. We're investing the returns instead of just letting the returns compound in the savings account. We leave the principal balance there and we loan out the difference. Now that's not the end all be all. It's a fairly complicated analysis, and so there would be accountants and experts and all kinds of witnesses and experts hired to resolve this. That's certainly going to be what the church's argument is. As a lawyer, I can find an expert to say something completely different. Experts, for lack of a better term, are testimonial whores. I pay them money; they say whatever I want them to say. It's actually fairly quite simple. But that's sort of it in a nutshell. So at a very basic level, they have a way of around it, but at a much more complicated legal level, they're going to have a heck of a fight to prove it.
I feel like we've only just touched the tip of the iceberg, Zac, and there are so many other things that we could touch on, but I want to give time to give some questions, get some questions answered by the audience. And
sure,
yeah, thank you. Firstly, would you be up for continuing this?
Oh, absolutely. If this becomes a 50-part series, we both win, so I'm good with it.
Let's do it. I'm down. And so anyone, if you're one of the 350 people watching, go and subscribe to Zac. His channel's awesome. My lawyer friend Zac Morgan. There's the link in the chat. There's a couple I've been bringing up here and there. NF Fangirl, I love that all these SBTV channels support each other 100%, and we're all here together helping each other. So Happy Puffin asks, could the actions taken against enemies be considered domestic terrorism?
No, probably not, just because in order to rise to the T word, the last word in your sentence, and then in the question there have to be certain acts of mass violence. And mass violence could be like the Boston Marathon situation, where where a series of pressure cookers had large numbers of casualties in the dozens or hundreds. It could also be the Washington D.C. sniper in 2000 or 2001, 2002, whenever that was. That was considered a mass casualty event as well, even though it happened over a 4 or 5 day period. Lots of people were injured. Lots of people were being attacked. So in this case, generally speaking, they're not acts of violence. They're threats of violence,
but the
but
action is different.
there would need to be an act of violence. Now, it certainly gives rise to a lot of other violations of criminal law: harassment, stalking, blackmail. Those are all illegal. But it won't. I don't think it would rise to the level of domestic terrorism for a variety of reasons. It's really hard to reach that threshold, and it should be. Right, two neighbors get liquored up, they disagree, and in the United States everybody owns 57 guns because the Second Amendment says we can. And so they start lobbing shotguns, shotgun blast at each other from across 3 acres of space. If we had a really small definition of, if we had a really narrow, a really broad definition of terrorism, theoretically that would meet it. The definition of terrorism is very specific, and it should be, because we should allow the rest of the criminal law to adjudicate these crimes without them rising to the level of terrorism.
Okay, fantastic. Jane Poet, question: are you saying if they do this all around the country, after the order is done, you could potentially bankrupt Scientology with all the money they would have to pay out? I think yes, right?
Yeah, anything is possible, but the number of zeros and the number of commas in these bank accounts is so unbelievably staggering that it would probably put a noticeable dent in the federal deficit of the United States, is the kind of money we're talking about. I would be surprised if the sum total amount across all of these entities put in one bucket, I would be surprised if it didn't near a value beginning with the letter T. I think that's how much money we're talking. We're certainly talking about tens of billions of dollars. And when I say you would get a contempt fine, $10,000 or $12,000, no judge is going to fine you $50 million for contempt. That would be an unreasonable response to the allegation. The contempt allegation, even if you're hiding assets, the conviction of contempt or a contempt penalty isn't to repay the money that you owe. You're only being penalized for that one contempt. A contempt of court could be, I got too close to somebody at Walmart who had a protective order against me. Didn't even know they were there. Just got too close. Never saw them. Right. That's the same contempt as anything else. So you're just penalizing the contempt, which would be, tens, maybe hundreds of thousands, but certainly not millions or billions of dollars for the contempt charge alone.
Could they, this is another tangent, and if it's too long to answer in a couple of minutes, we can bring it up next time. But if they lose their tax exempt status in the US, would the IRS be able to claim back the tax they haven't paid historically? Or would it be, okay, you were tax exempt, you're not now, and from now you have to pay taxes? Would it be possible for them to say, well, for the last 50, 60 years, you've not been paying tax because you were exempt, but actually we deemed that back then you shouldn't have been given exemption anyway, so you now need to give us $20 billion or whatever?
I think we do a video on this. I have a lawyer friend of mine that I know. I'm going to talk with him and make sure I get my information correct to answer that. I think it's a great question, but I think it's worthy of its own video.
Okay, fantastic. Sounds good. Love it. This is actually a good one. Vanessa P. Petty question: can a civil subpoena be served and or enforced internationally?
Maybe. Depends on whether or not the United States has an extradition treaty with the other nation. What would happen is, if you can't, now theoretically you could get service if I'm trying to serve Alex, divorce papers in the UK and I live in the States, I could
we
contact.
Have had a horrible marriage, Zach. We need to talk about
that. We'll just get some auditing. I'm sure that'll fix all.
Yeah, we'll be fine. Yeah, we'll just go clear and we're good.
Yeah. if I'm trying to serve legal papers on you, I can certainly contact a process server and go through the UK version of service. And it's a multi-step process, but I would hire a barrister solicitor in the UK after I effected service on you, who would then file a special type of legal case that basically gets a court order that says yes, he's been served under UK law. That order then comes to the United States and presented to the judge. The UK court says he's been served. He now has, reasonable notice of the proceedings. I need him deemed served because that's going to start the clock necessary to calculate when the response to the pleadings or the response to the subpoena is due. So yeah, absolutely possible. If you are running and we can prove you're running or hiding and we can get a warrant for your arrest, let's say you're subpoenaed to appear, I get you served, you then flee the country. You don't show up, the judge issues a bench warrant for failure to appear, and they find you hiding in the streets of London somewhere, and the US has an extradition treaty with the
They'll pull you
UK,
back, right?
then now I have an arrest warrant, but that's a different legal vehicle than the service of process or service of a subpoena. It's a different legal process, but it's a similar mechanism.
Sure. That's actually linked to this question, Keisha. Fantastic. If Alex gets fair gamed in England, is he able to file suit in LA, assuming judge rules Scientology can no longer fair game?
Maybe. It would, so he could certainly file suit in the UK. There's probably about a half a dozen different jurisdictions. What I mean by that is a half a dozen different places, countries, states, nations, in which Alex could file a lawsuit, and that would, he would meet with maybe a U.S. attorney and meet with the UK barrister or solicitor. I can't ever keep them straight. One's a transactional lawyer, one appears before the bar and argues cases. Can't ever keep them straight in my head. And although I would love to practice in the UK, I have absolutely no desire to put on my robe and wig and
And your curls. No,
yeah,
you don't wanna...
yeah, exactly. I have no desire to do that. It is still a practice in most of the Commonwealth nations, but it is not a practice in the States.
No, I love that. Okay, great. And then, so lastly, I just want to bring this one up. Question: does Zac have any concerns of being fair gamed?
Not till now. Not
Now you're
not
here.
yeah. Not necessarily. I have no direct connection to Scientology. I have never attacked Scientology. I simply answer the questions that I'm asked. There was a question asked earlier, and I said, it's very possible that they're not breaking the law as far as shuttling this money back and forth, right?
Yeah.
So I answer fairly. And if I were to be fair gamed, as a lawyer and being well connected in the law enforcement community, it would not go well for the person who's attempting to fair game me. I mean,
and they have much bigger issues on their plate at the moment with Leah Remini and so on. There's so much going on. I don't personally think that their priority is going to be on taking down your channel or fair gaming you, because they've got to organize and direct all of their resources towards these huge legal cases that are currently ongoing, not bringing up further attacks and so on. I might be completely wrong, but I understand that they've got a lot on their plate.
Well, and I try really hard not to make accusations. I give things that are clearly opinions. So, it's, I don't want to say it's defamation proof. I can sue anybody for any reason in the U.S., but defamation requires a statement of fact. I don't make statements of fact. It is my opinion that. It is my opinion that. I could be wrong. You could get 10 lawyers in the room asking the same question and get 10 different answers. My dad likes to say the best lawyer is a one-handed lawyer because you can't get on the one hand and then on the other hand. But the best lawyer is a one-handed lawyer. So, not necessarily. I also work in an environment in which we have armed security around us 24 hours a day. In higher education, I work in an industry where all of my facilities that I work in higher education, we are overseen by the Transportation Security Administration, the Federal Aviation Administration. We have commissioned peace officers who are law enforcement officers who carry guns, who are responsible for the security of my employment. We also have community law enforcement who work for the town and the county. We have statewide law enforcement. So, it's a do so at your own risk. And to be honest, if a PI were to follow me, it would be fairly boring. I wake up, I go to work, I sit at my desk, I do my thing, I teach some class, I come home, I go to bed. It's not terribly exciting. Might go for a walk from time to time, might go to the gym from time to time.
They're not going to dig up dirt, right? Yeah,
Yeah, I'm not meeting in underground bunkers with people trying to overthrow the world. They would spend an enormous amount of money to get a report that you could copy and paste every day.
fair enough. All right, this is going to be the last question because we need to start wrapping up here. Jess, thank you so much for your super chat question. If COS can prove they don't have enough money in the bank, can they be forced to sell their buildings and other assets?
Yes, and ultimately, depending on the state jurisdiction, it's very possible that in some cases the plaintiff gets to pick the assets. Got a $100 million judgment, you got $110 million in the bank. Cool, keep your $110 million. I want those 14 buildings over there on Hollywood Boulevard.
Interesting. All right, and then there is one more that's just come through. Ms. Pellet, thank you for the super chat. Another writer. John, you can read this out. I've been reading them all out. Go on, Zach.
Sure. So she posits another item that could cost the church is that they're also likely to enjoy property tax exemptions in some states. They actually enjoy property tax exemptions in all states. That's part of the reason they invest so heavily in real estate, as part of their investment strategy. You don't want to just sit with enormous amounts of cash on hand. They still have an enormous amount of cash on hand, but one of the ways you can get rid of your cash on hand is to invest in real estate because you're not subject to property tax. If they were to lose their tax exempt status, then yeah, they would certainly be taxed on all of that real estate, and not just at its current taxable value, but also on the increase in value from the time they bought it to the present day, the day their tax exempt status is removed.
Wow.
So yeah, they're looking at
Fascinating.
huge financial penalties. That's the backside of investing in real estate. As a nonprofit, if you were to lose your tax exempt status, you would have some pretty significant property tax issues, and the
It's a
government would be
big
placing
risky
tax
game.
liens on your property, which would encumber the ability to freely convey it. If they did want to sell it, there'd be a lot of issues there.
Fab. Zach, thank you so much for your time. Everyone in the chat, if you're watching on my channel, go and subscribe and follow to your lawyer friend, Zac Morgan. Today is Goldie's birthday, so happy birthday to Goldie. If you want to support her, I have merch on my merch store, apostatealex.com. There's a Goldie merch section, and all of the money from the Goldie merch goes straight to her because I thought, how can we give back to her? So if you want to support Goldie, it's her birthday. Go get her some merch. I'll send her the money from that. But otherwise, thank you so much, Zach. Thank you everyone for supporting and watching, and let's definitely do a part 2 soon because there's so much more we didn't cover.
Absolutely, this is part 1 of me. We'll get together and do it soon.
Let's do it. All right, thank you so much, guys. We will see you very soon.